This is a special interrogatory. This is the caption. See it screwed up? No parties' names. It's all messed up. On purpose. If you leave it like that, you're going to lose those points in the matrix. Rubric. I call it matrix. It's a rubric. Okay? You got to change this. No judge. Special interrogatories of claimant. Claimant deals with arbitration, not litigation. This was an arbitration case. So you have to change claimant to plaintiff. And I'm talking about just these are like little things, you guys. You have to make sure that the font is correct. Times New Roman, 12 points. Not Courier, 14 points. You have to make sure the footer is correct. The rules of civil procedure are correct. I would suggest, though, any document that you ever get, you research them, and all you have to do is cut and paste this actual right here and put it in Google if you want to determine if it's correct or not. I would suggest that you just go and look it up for your own self-awareness. All right. And then the language in here is pretty boilerplate. You can copy it. The only problem I would have is that these are special, and Robert, what you were asking me, these are special interrogatories. They're drafted. I drafted these documents. These are drafted for an employment case. You cannot use the exact same interrogatories that I have. One, because they're not applicable. Two, it's plagiarism. And three, actually look at these documents and grade you down if you do that. So that's probably the most important part of it, right? So if you just say, I'm going to revise and I don't have enough time, I'm going to take Chris's interrogatories. I can see. And like my daughter now, I can read. So she's reading the book to me. Shut up. Shut up. Shut up. I didn't say that. But I think so she got swag on the little book, and it's like anyway. So I read and see, change this stuff. But you see, I can form in the Robert's asking, can you ask the question you want to? Sure, you can. Be careful though, because if you write it too convoluted, well, tell me that you were outside on the day before when it was raining and you did an objection. Compound, attorney-client privilege, work product privilege, false speculation. I just throw a whole bunch of objections anyway. But so we'll talk about objections in a minute. But you have to streamline your question. Specify the number of complaints made to you or any government agency regarding sexual harassment in which involved any defendant. Okay. Now, if you wrote specify the number of complaints made to you or any government agency regarding sexual harassment, and not referencing the actual defendant, they would say objection. Because who are you talking about? And he said, well, you know we're talking about you. We sent them to you. Now, you got to be specific. You know, they won't respond. They put objection, they won't put a response. We don't know what you're talking about. That's the response. So you have to streamline your questions to what you're trying to, exactly what you're trying to get. The more basic you make it, the better. Admit that you entered a contract with such and such on this date. Admit that you entered a contract with such and such on this date. If you entered into a contract with such and such on this date, you have a copy of it. I don't know, but you have to be streamlining questions. For each pleading, for each discovery, besides the form interrogatories, you have to have 5 questions, at a minimum 5 questions. So the special interrogatories, the RFA and RFP, must have 5 questions each. Not total, each. Admit that you did this. Produce all documents. So those are different types of questions. And you'll see in the sample. Right? Questions? Yes.
Can you go over 5 questions or just 5?
I can go over.
Oh,
no.
Yeah.
Okay. All right. Any questions? Yes.
Pleading paper. Is there a form for template or?
It's simply in Microsoft Word. Microsoft Word, you put in pleading paper and you get pleading paper with line 1 to 28, I believe it is. Or, when I post these, you just take my name and copy it and use it. You got to get the codes out of them. Some of them have codes on them. Microsoft Word has codes and you copy and paste stuff, and it doesn't come out like you want it. You have to make sure that you don't have codes in it. Or at least fix it. I don't get the codes out. I was illegal. I swear to God, I'll sit there for like 6 hours. I can go research and give you the answer to sexual harassment and discrimination. You ask me to get codes of a document, I'm sitting there like this. And I wouldn't touch nothing. This is bad. Like, I don't know. Don't you hate like if you take a document and you trying to move that paragraph out and it doesn't move like wherever else at, and you wonder why it doesn't move out there? I don't know why it doesn't do that, and I just give it to Fairly to fix it, and she does. She YouTubes it. Yes. I don't ever go on Blackboard. So with that said, I don't know, but with that said, I'll make sure it gets posted. It gets posted. I never go on Blackboard. People are like, is that on Blackboard? Oh. I don't have access to it. More access to the height. I think I've used it just. Okay. All right, questions. When you turn this folder in, it's going to have all these documents in it. 3-ring binder, 3-ring hole, but not put in those little plastic things. It's hard to get out. The sleeves. It's not cute. It's not fun to do that. And I get mad at the grade. Remember, it's all about me right now. No, I'm just saying. I want to be happy when I'm grading documents. But when you put them in the little sleeves, it's miserable trying to pull each one out. So don't do that. 3-ring binder. It can be like one of the ones that hold like 25 pages or 30 pages. Costs like $1.99. You have to spend $1.99. I'm sorry. I know this program was expensive. That's way too big.
No, I mean, but with those.
Yes.
Right? Okay.
Yeah.
Yeah, you don't have little half-glass.
It has to have the binder.
Yeah, just make the holes and.
Yes. So not no. No. It has to have the actual 3-ring binder. I don't know what the plastic paper is.
No, 3-ring binder. 3-ring binder.
And the reason why, one, it's easy to grade. Just turn the page and grade, and I can see it. But it also helps you organize. You have a 3-ring binder complaint. You have all the documents. Then you have a sleeve, not sleeve, a divider. It goes to discovery. Discovery documents should be separately stapled. So if it's form interrogatories, they shouldn't be stapled with special interrogatories. It's its own document. You staple a complaint. You don't staple the summons, civil case coverage, civil case coverage. That would be fun. Obviously, it has more than one document. Staple it. Proof of service is staple it. I think the case cover sheet has one in the instructions, so staple it. These are just formatting things. You won't let it get written down for doing it wrong, but just trying to get you to do it right. It's kind of just more of a logistics, what we will. So we did form interrogatories to work 5 points, special work 5, request for reduction work 5, RFA, all these work 5. 5 next to these. And this is a real next level. Alright. So I'll show you special interrogatories. Just go do it in the attorney's name, law firm, the date, within. Do not do it like this. This is a bad sample. This is a sample. Never put the signature line on a page by itself. Never split the signature line.
Why do you do that?
Mine? Why do you do it like this now?
Yeah, why do you have it like this?
So it's messed up, so you guys can fix it. All you have to do in this page. See, down. See, so there. See. I don't know what's wrong with it. Anyway, this stuff goes over here, right? Because I don't know. I told you got codes in it. So remember, mine is a messed up document. It will have codes in it, so you have to fix it. As you see. All right. And then make sure the footers. This don't take this declaration out. Don't put this on there. It has this is a declaration. If you have more than 35 questions, you have to have a declaration saying why you want 35 more. I had 51, so you have to give a declaration by attorney. None of you guys will have that many questions. Most of you will just have 5, which is fine. But I want you to put it there. You can read it and take a look at it. Just so you can see what's up. Yeah. All right? We're good with the special interrogatory.
So with the is,
Which one? Form or special? 50-50 chance. I got it.
see 35 questions, and then if you get those answers, and then typically if I hear an answer to a question, I'll get another question. You can send another special introductory if there's something pertinent in the case to me that I don't have to.
Set number 2. So by that time, you probably take a deposition. Yes. Right.
You kind of shoot in the dark sometimes when you're sending questions, right? But you don't know what may be pertinent.
No. You know what your case is about. That's the point of being familiar with law and case, so you can know what to ask. This is request for admission. Again, his captions messed up, so fix it. I would try to get you guys all your captions in the uniform. Make it all look the same. Obviously, you don't have a judge, so take that out. Take the date the complainant out. Take the trial date out. We don't have any of that stuff. Knowledge of the code section. These are the definitions for our case. You gotta go through this. And the reason I'm going through this fast is because we will have a discovery part of the class. This is now just trying to show you the documents. Request for admissions. Admit that you terminated plaintiff without cause. If they admit that, we win. All right, and they won't admit it, but you have to put it in there. And if they deny it, and then they go back to 17 point over the form interrogatories, they have to explain why they did why. That's why I used it. Go to the admissions. This is not complete. If you leave blank line there, you lose points. That's me redacting it and taking my saying out. All right, admissions. Law firm. That's not PLC is incorrect. It's APC. It should be correct. That's my name. All right. Request for admissions. Granted, we're going to go over all this in depth. We have discovery. Any questions regarding the form of request for admission? The document request for admission. Sample notice deposition. You don't have to have a request for production of documents with your deposition. So all you would do is notice the deposition of the party name and take that off and leave it. Take the department name from the judge off, clean all this up, check the code section. These are the RFPs with the notice deposition. I want a separate RFP. Follow the rubric. I want a separate RFP. Having an RFP with your notice of deposition will not get you the full points. Yes.
This, I know we're going to go over, but just because the request for production documents is a request for the defendant to produce the documents.
If the plaintiff is serving, yes. If the defendant is serving, it's a request for plaintiff.
Right. In the context of ours, that's what
correct. It's the defendant producing. Right. Got it? You with me? Still, we only got like 20 minutes. Yes, separate RFP. Because you see this notice of deposition has notice of deposition with request for production of document, right? You can keep it like this if you want to, but you have to change the request for production of document questions. I would just delete all the requests for production of documents and make a notice of deposition without request for production of documents. That's what I would do.
And then typically notice of deposition is set the time for the deposition.
Absolutely. Right here.
So, okay, so we want to leave it or just make one up?
Well, it has to be per code, and we haven't got that part of it yet, but I would set it out probably 2 months after I'm supposed to. I would set it out a month after I'm supposed to receive responses to the discovery. So, practically, if you discover on 14, Thursday, we serve it on that Thursday by mail. We have 30 days, 30 plus 5 days to respond, right? That goes to about July 14th. 14th plus 5, July 19th. You guys know what I'm talking about or no?
Yes.
All right, somebody got the 9 calculator.
Just thinking about calendar day.
Approximately July 19th, right? We should have all the responses back by July 19th. There might be some extensions, so I'll probably set the definition out for early August.
Do holidays,
No, calendar days. Only thing it affects if you do on a holiday, then you get the next day. So practically, you would say early August. You want to set the date. That's just probably when you have all your discovery responses. I can get my discovery responses back before I take that decision. Then I have all the documents and all the other information I need to follow questions on. So that's another deposition. What am I missing? RP. A lot of documents. I don't know. I don't know. This is not my law firm anymore, and that's not the address, so make sure you have the right one. Why is it showing like this? Request for production documents. Make sure you change to the definition section because employer, employee, employee, employed, employed, employment does not refer to anything that we're doing in this case. So you probably need to take everything from 8 and delete it. You understand why? Because you're not using those terms in your request. And then you have the same type of questions. You ask all documents which relate to performance of plaintiff during the time period. Look at the plaintiff, like piece of plaintiff. You have to fix that. What? Yeah. All right. So it's a lot of. And the reason I want to show you those documents is to show you that there's a lot of mistakes in those documents that you need to fix. And that's where we go to the organization and writing grammar, and that's where you get those 15 points. People have received 105 points off of this because they've done perfect work with 5 extra credit. And people have received 70 because they missed documents and they did shabby work. Don't miss documents. It's easy to get 85 points. Any questions? If you turn in late, these are the reasons you turn late. Non-compliance with the style, time in the wrong 4-point double space. You will lose points. And it's not on time. All right. Any questions? No, if you turn in late, it's definite. It's possible because you haven't turned in late yet. It becomes definite when you turn in late. All right. So this is an actual retainer agreement. I don't know if we use this one anymore. But when the client comes into the office and we've done the client interview, we met, we've partnered up with the paralegal, we decided we want this case. Okay, we have to send the client a retainer. The retainer is a contract between the client and the law firm to identify the responsibilities of the client and the responsibilities of the law firm, understand what our role is and what we will do, and to show how we will get paid, and if we will get paid. I believe this one is an hourly retainer. So you have different types of retainers. You have an hourly retainer, and you have a contingency retainer, and you have a flat fee retainer. With the hourly retainer, you can have an earned retainer and an unearned retainer. An earned retainer is usually happening with criminal law. An earned retainer is saying, we want your case, we want it, but you have to give us $50,000 right now, and we're $1,000 an hour. So you deal with the transaction trial. What do they do with the criminal part? You have to give us $50,000 to retainers, which is earned. We get that. That's our money, and we charge $1,000 an hour. And so you have to pay $1,000 an hour extra. That's the earned. An unearned retainer, which usually happens with civil cases, but also can happen with criminal cases. Say, okay, we want an unearned retainer, meaning that you have to retain us, you have to give us a $20,000 unknown retainer. We'll put that in our client trust account, basically escrow, and we bill out at $500 an hour. And every time we have a bill, every time we have an invoice every month, we'll submit it to you, and then we'll pull from that $20,000. So we haven't earned it yet. Earned. Now, if there's money left over and we settle the case, I mean, we have to resolve it, and then there's $10,000 left, it goes back to the client. There's no more money left, and we exhaust that $20,000, and we're still litigating. The retainer will say, "Hey, you have to give us another $20,000 to put in escrow to the client trust account," and we'll pull from that. And that's to make sure that you get paid. Just to make sure the clients will not pay you. They don't like paying. But it really don't. It's like anything else. Like, I did legal services. You owe me $10,000. Okay, I'll give you $5 now. Hell no, you give me my $10,000. And so if you don't have it, you have it in escrow, you can get it. If you don't, it's just like any other bill collector. And I'm terrible at collecting bills. I'm a little aggressive and mean. I gotta pay for my daughter's tennis lessons. So put in the escrow, you have the money there. I would tell you most of my cases, I would probably say only about 10 or 5%, maybe 5-10% of my cases are actually hourly cases. Those are my business clients. Most of them are contingency. So I'm gonna have us there post this. So if you want to look at, is this on? This one is on. Okay, you should take a look at it. Like I said, if anything else, will there be a lot of testing on it? No, but it's good to know. Good to have the information. All right. We're going to talk about computer. All right, contingency retainer. All right. Lord. Contingency retainer. Go. Yes. All right. Here we go. So again, this is a contract between the parties. We identify the purpose and retainer agreement, the scope of the representation, and it really does the same thing. It talks about the duties of the client, duty of EAA, etc. Here's the difference. One of the main differences is the contingency fee part. In lieu of paying attorney fees for services performed by EAA on an hourly basis, client agrees to pay EAA a contingency fee, which will be calculated at 33 1/3% of any amount covered on client's behalf prior to trial setting conference, and 40% of any amount recovered on client's behalf thereafter. It's more work to prepare for trial, or more money. It's just standard. It's just standard. And it goes on. But I also know here, the amount of the contingency fee set forth in the retainer agreement is not set by law, but rather negotiable between EAA and the client, and it's according with the civil code. With the California Business Professional Code. Meaning that you don't have to agree to 33 1/3%. I usually do not reduce my fees upon the inception of the case, but as the case goes on, depending on how it's looking, I might reduce my fees. Sometimes I get down to 25%. I won't go lower than 25%. Sometimes I go 30, 28, and so for purposes of making the client happy, if we can settle it, if I can reduce my fees, I will. Like I said, what's the difference between $5,000 and $10,000 in a big ground scheme?
I'm just curious why you would reduce. Like, if you settled it early, or
if I settle, settle early. Maybe, if I settled early and I feel like I didn't do as much work as I thought I was.
Really?
Yeah. Or if sometimes if the case, if we have a settlement amount in the client, because like I said, for the purposes of me, is there a difference between $2,000 and $6,000? Really, 6 and 10 in the big grand scheme? No, but for the client it is. And if that can motivate the client to sell, it takes the case off my docket. It gets us resolved. The client's happy. I'm happy, and I don't have to do more work on the case. Because from my standpoint, from a business standpoint, if we're the difference between how much I need to reduce percentage-wise on my if I need to reduce a percentage of my contingency fee agreement, if that's the difference, and that's the reason why we're not going to settle, I'm going to do way more work in preparing the case going forward in that difference.
You're looking at how much work you have to do for that 2,000, for that 3,000.
Correct. If it's not worth it, then I will eat it. Yes, it's just a business decision. And honestly, the clients are happy to do that. They already feel that, nobody appreciate. They don't realize at the time that you're not paying anything for these legal services. They don't realize at the time. But when the check comes, my mind, right? It's mine. Hey, you didn't pay my legal fees. Pay my third. I gotta pay you a third, bro. And showing a retainer agreement, and they're like, well, no. And so it's just human nature. Mine, I don't want to give it to you, even though you owe it to me. So
Does it go to you first?
yeah, absolutely. I would never see it. Absolutely. But it goes into a trust account. So if I get a check for $100,000, a third of that goes to me, and the third goes to the client. But it's in the name of a law firm, and it's in the name of the client. And then it goes into the trust account. It clears. I pay the client from our trust account, and I pay the law firm as well.
Would it be fair to say that there's a case of the rough facts that are on the plaintiff's behalf, or maybe one negotiating behalf? So, like, let's say the plaintiff has a really strong case, looks pretty clean cut, and have no one at all. Would they have more negotiating as opposed to one? Well, you could have a case. You don't know, how the discovery could play out. And I have to do more work and not negotiate. My own view of this.
Possibly. I mean, most attorneys, for the most part, we charge the standard third, and you can go to another law firm, they're going to charge the same. So if you have a really strong case, yeah. But at the same time, if you have a really strong case and you thought you were going to mess up, you wouldn't need an attorney. So, just like doctors and dentists and any other professionals, we value our services and legal services we offer. We want to be compensated for. So I don't know how much I'd be willing to negotiate down. What I would do, if you want to pay me a flat fee up front, I will reduce the contingency amount. So if you want to give me $15,000 up front, I'll reduce the contingency amount to 25% or 20% on the value case. I've done that. So that's called a mixed retainer. One of the things that the contingency agreements are costs, which are different than legal fees. Costs are valley fees, paying for deposition, paying for mediation, parking, traveling. These all things cost money. Usually, industry clients don't pay those money. That doesn't have money to pay. So the firm advances these costs. So when I file a complaint, I'm using my firm money to file a complaint. When I pay for a deposition, we pay for a freaking deposition that costs $1,200 each for 4 people. I hate depositions. I'm paying that money out of my pocket. And I'm looking to recoup that money from the settlement. That's why I'm paying it. So I'm advancing. Now, if the case settled or we get a judgment, then my cost comes directly from that settlement judgment before my attorney fees. I get my money back first because that's money that I paid out on your behalf for the case. You understand? All right? Then the legal fees come out. The clients always act like they don't read this provision. Mediation, I went to mediation yesterday. It was mediators were killing. It was $300 each. When we were there 9 hours. I think he did much. He went back and forth the room. I think he was sitting there eating lunch in the middle when he left the room. I think he was just but that was the cost that I had. And my client, I know was going to say at some point, I have to pay that? Yes. So those are costs are separated. Now, if the case doesn't resolve in our favor, then I get the cost back from the client. At some point, I know how the case is going, and I might just send them a bill like, "Oh, we're in trouble. I got to get my money because now if I don't get it now, I'll never get it." I haven't experienced that. Oh, I'm about to experience it on Friday, but I haven't experienced it before Friday. It's a small cost though. It's just maybe $800, but it's still my $800. Like I said, I'm human nature. My money, and so I know I'm not ever get back to clients. I'm kind of eating that too. Eat a lot of stuff. But the problem is, it all sets with other. You might get like an DUI case and have to, cost $3,000 to do it. You might go do, one appearance. Is one appearance worth $3,000? No. But I'm keeping that $3,000. So, all right. These are the retainer agreements. only thing we need to do today was in-class group assignment. Don't worry about it. It's not going to be held against anybody. Don't worry about it. We went to the pre-lawsuit consideration. For class tomorrow, we're going to have more theory tomorrow. More theoretical. So, read chapters 3 and 4. Anatomy of a civil action. I'm not bringing the movie. I might bring the movie and watch part of it. Civil action. Can't watch the whole thing because that's a fact. But party civil action. We'll talk about it before. Maybe you guys want to watch it. Have you seen Civil Action? It's a really good movie.
You can get it on Netflix.
No, I know. Because I got Netflix. I'll tell you a story about it. But I'm bringing in. If you guys want to watch it, let's do it. Because it's none. It's actually very, very practical. Watching it. We'll do in the beginning. We'll do party civil action, and then we'll do the anatomy of a civil action prior to the movie, which will probably take about 30, 45 minutes. It won't be 2 hours. You'll watch the movie. It works? All right. So I'm going to get this syllabus thing worked out, but you guys know what I told you is what's happening. Final project is through the last day class. We will have a final examination, which is multiple choice. All last day classes, open book, open note. You have 5 extra credit points, which are part of the project. No deposition subpoena. And you have reading chapters 3 and 4 tomorrow. And I'll see you guys tomorrow. Thank you guys for being very patient and understanding. You're awesome.